All right, so now we want to take a look at how these agency relationships are created, some of the requirements, obviously by law. Because up until this point, we've really been talking about what agency is, some of the requirements when you practice under an agency relationship. But right now, we're going to look at what the law says about actually creating the agency relationship. And some of this is actually just going to be a review. But first thing it says is the state law. We discussed that already, but it's state law or statute that requires agency relationships have to be created or established in writing. Okay, that's the agency agreement. And a little bit later in this hour, we're going to actually talk, excuse me, we're going to actually talk a little bit about the different types of agency agreements, because you got some options there. Obviously, all of them would create the relationship, but there are a little few differences depending on which type of agency agreement or contract you decide to use. In that second bullet, obviously, another review statement, but implied agency in South Carolina is illegal. We know we can't do that, so you can't just say or suggest to someone that you're going to represent them if they have not signed a written agreement. Because again, up until they sign that contract, you're still a transaction broker, and the person you're dealing with or working with is considered a customer, which means you cannot provide professional services, and you are extremely limited on what you can do for them at all. So just be careful that you don't get yourself in a mess by saying things or doing things that would have that buyer or seller, for some reason, think that you're representing them, because that's where you've crossed the line. That's where implied agency has now been created. Anyway, so we beat that up enough. And then here, now we need to talk about this agency disclosure. Again, we talked about this in an earlier hour. You've got to disclose agency. You got to explain agency and the relationships to potential buyers and sellers. I mean, how can they agree to sign a contract to create a relationship if they don't understand it? If they don't understand what is required or what it all entails. So the law says, and this is really cut and paste straight from the law, and it says the licensee shall, now, I'd pay attention to the word shall. When I read that word, it doesn't sound like it's just a suggestion. These are things you're required by law, but you shall provide at first practical opportunity to all buyers and sellers with whom the licensee has substantive contact. And then you see there's two things the law says you must do at first substantive contact. So let's take a look at what these two are. Number one, you got to provide a meaningful explanation of the agency relationship. You have to explain this to them. So how do you do that? It's really not that difficult. Basically, I tell buyers and sellers for that matter, but say I'm working or talking to a buyer. And let me back up a second. If you look at that first statement up there in the law, it says, these two things must be provided at first practical opportunity when you have substantive contact. Now, how do you define that? What does substantive contact mean? Because at some point, you got to say basic timeout. We can't talk, can't go any further until I disclose some things to you. When does that take place? When does substantive contact, or when is that created? And the way the law kind of reads through that section, basically at the moment you start talking about real estate in a trying to think of the right word to use here, but in a substantive way. You know, can you just talk about real estate in general to people without having to disclose agency relationships? Yes. Y'all, people will be coming up to you, hey, Frankie, how's the real estate market? What's going on? Prices still going up? Are they coming down? You know, that's just general conversation. Not a big deal there. But if somebody walks up to you and says, Frankie, hey, I'm looking at buying a house or selling a house and wanted to talk to you about it, well, now that's more substantive. And you've got to stop them from going any further. You better be very careful in how much you let them tell you before you've made this disclosure. And you're going to see why I'm saying this here in a little bit. I'll further explain. But for right now, I just want to make sure you understand when is substantive contact. And basically it's when somebody is expressing a personal interest to buy or sell or refi, whatever they're asking you to help them with. Okay. Anyway, but at that point, first thing you have to do is call time out and say, well, look, before we go any further, before we discuss anything, some things we need to talk about. First of all, if you're seriously considering buying a house, or if it's a seller selling a house, then I need to explain real quick to you about a relationship called agency. It's an agency relationship that would be between us or you and the company actually. But basically it works like this. If you're going to buy a house, I can help you if you become my client, or I can help you if you want to be a customer. Now we can do it either way, but there's a big difference between the two. And here's basically in a nutshell the difference. If you choose to become a client, which obviously I hope you will, then I will be representing you in a legal or fiduciary capacity. Means I have to promote your best interest, get the best deal I can possibly get for you. But most importantly, what I want you to understand, at least for right now, as a client, anything you tell me can and will be kept confidential. In fact, it must be kept confidential by law. So as long as you're a client, we can discuss things freely without you worrying about, am I going to go tell somebody else or share this with some other party that could come back and bite them at some point. So there's strict confidentiality, because remember, confidentiality is one of your fiduciary duties to a client. But if you decide to stay a customer, which by the way, right now you are considered a customer. And as a customer, I cannot represent you at all. I cannot offer advice and I cannot offer any opinions. All I'm allowed to do would be what we call ministerial services or administrative type things. So basically, in no way, certainly professionally, can I help you as long as you're a customer. The other thing I want to make sure you understand, buyer, as long as you're a customer, I do not owe you confidentiality, which means I could, if needed to, repeat things that you tell me. Okay, so in a nutshell, that's what agency is. And now, buyer, based on that, do you want to stay a customer and basically do this on your own and I can just do some administrative support for you? Or would you rather become a client and then you get full legal representation to include the confidentiality? Now look, so why did I go over that and have to do this abrupt timeout when we started initially talking real estate? Why did I cut them off and say timeout before you go any further? Y'all, because right now they're a customer and I cannot potentially keep things they tell me confidential. And so in essence, you're having to read them their rights. Y'all, before they start spilling all their beans, you got to read them their rights. That's what you're doing here. So through our discussion here, I just want to make sure, before you start telling me things, if you expect me to keep what you tell me confidential, then you need to seriously consider becoming my client. Because as a customer, again, which is what you are right now, I cannot keep anything, or potentially may not be able to keep things confidential that you discuss with me. So y'all, that's why you got to do this at first substantive contact. Y'all, you can't wait for this meaningful discussion going on. Like, the buyer telling you, here's what I'm looking for. Here's a biggie. Here's how much I've been pre-approved for. Y'all, do you think any seller would love to know how much the lender will actually loan them? Yeah. Y'all, that's confidential information right there, right? So before they spill all this information out to you, because I promise you, because they don't know any better, they're probably just assuming, because you're a professional, you're not going to use anything that they tell you against them. And look, and I wouldn't intentionally, right? I would never do anything that hurt anybody else intentionally. However, if they tell me this stuff and I know what they're approved for, and maybe they're interested in the house that I'm listed for. Y'all remember, if the seller's my client and I owe them full disclosure. So y'all, if there are things I know about this buyer and they're not my client, I do not owe them confidentiality. Can you see where this can become a problem down the road? So you either got to tell your client what you know about this buyer, which is going to hurt the buyer legally, but it's going to hurt them more potentially. Or you just say, well, I'm not going to say that because that would hurt the buyer. Well, then you're withholding information that you know from your client, and that's a violation of your fiduciary duties, right? So, at this point, it could be somewhat complex, or it sounds like it is. I'm telling you, it's really not that big a deal. It really isn't. But you just tell them, basically, you've got an option if you want me to help you buy a house. You can choose to become a client, or you can choose to be a customer. Here's the difference between the two. Which would you prefer? Now, typically, they're going to say, well, I want a client. And by the way, at least for me, okay, I'm not suggesting this be the case for you. You can make your own decisions here. But in terms of what I charge for my services, it's going to be the same, whether you're a customer or a client. I'm not going to discount how much I get paid based on what you want me to do. No, here's what I get paid. Whether you want the full service as a client or very limited services and help as a customer. It's going to cost you the same if you work with me. Now, so, obviously, if you're the buyer, what do you think you'd prefer? Well, I think I'll be a client, right? That offers the most protection and the most professional services you can get. All right, well, I'm glad to hear that. Now, by law here in South Carolina, buyer, if you want to become a client, and I'm very thankful and hopeful that you will, the law requires this relationship between us to be put in writing. So there is what we call an agency agreement that we'll both sign, and that creates this legal fiduciary relationship where now I owe you, these fiduciary duties, and you can go through those and whatnot. I guess at this point it might be fair to say, is it possible, especially if the buyer maybe they don't know you that well, or maybe not at all, is it possible to say, well, no, I'm not willing to sign anything right now. I'm just trying to get some information. I'm still trying to figure out what we're going to do. Yeah, that's possible. And if you don't want to sign right now, obviously that's up to you. But again, I just want you to understand, up until you do sign it, you're a customer. So you can't just say you're going to be a client, because you're not a client until you sign it. And while you're a customer, I'm begging you, I'm asking you, do not share any information with me that you would not want somebody else to know, because I may not be able to keep it confidential. Not if you're a customer. So basically, I've read them their rights. Okay, I've done my part. I've done all I can do for them. Now I will tell you, I hear agents tell me that all the time. People don't want to sign. Yeah, I got to be honest with you. I'm not saying I've never had somebody refuse to sign, because I'm sure I have, but it is rare for me. And we might as well just be honest about this. If somebody says I'm not signing anything with you, what do you think's going on here? They don't trust you. For whatever reason. I'm not trying to suggest you've done something or given them reason to not trust you. It may just be they just don't know you, or just something doesn't feel right to them. But more times than not, it comes down to a trust factor. If I trust you, what have I got to lose here? Right? So anyway, that's number one. We got to explain or provide a meaningful explanation of the agency relationships. And then number two, there's actually, it's like a brochure. They call it an agency disclosure form. And it's prescribed by the Real Estate Commission. In fact, there's a copy of it right there in your book. You might have to turn a page or two or something like that, but it's a 2-page front and back. Actually 1 page front and back. But it's just a brochure that basically spells out or explains exactly what I just went over with you. And what this second requirement is saying is, whoever, anytime you're disclosing the agency relationships, y'all explaining it, then you have to get that buyer, whoever it is, they have to sign that brochure. So you probably want 2 copies of it. Obviously, a copy that they can have, just give it to them. And then another copy that they actually sign, and you need to keep that in your file. You're expected to maintain that document. But they have to sign that. Now, if they refuse to sign that, I suggest you run, because things it will not work out well for you at all. Because by signing that, first of all, it's just a brochure. In fact, it says, you see a little highlighted area right where it says signature on that second page. It says very clearly, this is not a contract. Your signature is only an acknowledgement that, number one, I explained what the agency relationships are, and that I gave you a copy of this brochure explaining it as well. That's just an acknowledgement that I have to have in case I'm audited, to show that I did, in fact, 1, give you a copy of this brochure, and 2, explain agency. If they're not willing to sign that, very little, if any, good's going to come out of this. Because, this isn't even a contract. You can't even acknowledge that I gave you something? You're not willing to even do that? Nope. All right, well, have a good day. See you. That would be my suggestion to you. So, again, the law is requiring 2 things better happen. Obviously, you better remember what these 2 things are and when it must happen. And it says this at first practical opportunity, or when you have substantive contact with either with the buyer or the seller, whoever the principal is. Got to explain the agency relationship, and then you got to give them a copy of the brochure and get them to sign it. They have to sign it. Again, not an option. And if it's a couple, husband and wife, for example, they both need to sign it. But whoever you're going to be dealing with, they need to sign that brochure. If you need to add a line or something, do what you got to do. But they need to sign that brochure. All right. Then it goes on, and And what it's saying in this next section, again, obviously you see it on the PowerPoint slide, but all this is in the book. If say you're listing the house for sale, then you're going to have the seller sign a listing agreement. That's the agency agreement. Call it a listing agreement. But in the listing agreement, and you'll see it's already there, but the seller will basically have to initial a line there saying that they acknowledge that they received a copy of the brochure that you hopefully gave them. We just talked about it. And a meaningful explanation of what agency is. So the seller, there's a statement that says that, where it says, I have received a copy of the brochure from the agent and an explanation of what agency is. Then they have to initial off on it inside the agreement, acknowledging. So this is really, so you got two forms of acknowledgement. One, you got the brochure, or you better have it. And then they have to acknowledge again inside the actual agreement. And then the next thing you see there is the buyer's. You have to do the exact same thing with buyers. So in the buyer representation agreement, it will have a exact same statement, and the buyer will have to initial acknowledging they got the brochure and an explanation of what agency is. Okay. And then that third bullet says the seller and the buyer must agree in writing to dual agency after the seller signs a listing agreement and the buyer signs a buyer agreement. This is important right here. In fact, this can cause you a problem on the exam if you don't get what this is saying. And quite frankly, a lot of agents have lost their license over this mistake. But let me just give you an example. Might make it easier to understand what we're talking about here. But let's say I list a house for sale. Obviously the seller's my client. They signed the listing agreement. Everything's good to go. But then a buyer contacts me because they're interested in this house I've got listed, which in it right now, and they don't have an agent. Okay. And basically they want me to help them. Now, can I help them? Can I represent the buyer as a client and the seller? Yes. Now, what kind of agents is that? That's dual agency. Now, before you can just start helping or doing any business here, they both, remember, dual agency is legal, but only if both the buyer and seller acknowledge that you're representing both of them, and they're okay with you representing both of them. Okay? So before I can do anything with the buyer, you can't be writing up offers, you can't even be discussing anything with the buyer at this point until you advise them or disclose to them that I can represent you and would be glad to represent you if you're interested in this house, but that would require a dual agency relationship, right? Which means I would be representing you, buyer, and the seller. I can do that. It's not a problem as long as you agree to it. But I must tell you of the remember there are 6 fiduciary duties that I owe my clients. But because it's dual agency, 3 of those duties become limited, right? You remember that? So, you just got to disclose all that to them. And as long as they're okay with it and agree with it, and then we have, it's just really just a 1-page document called a dual agency agreement. You'd have the buyer sign it. And then you got to go talk to the seller, because you got to make sure they're going to agree to it as well. So don't start writing up offers or doing anything with that buyer yet, because you still don't know if you can represent both until you get both of them to sign that agreement. Don't try to put the cart in front of the horse. I know a lot of agents that y'all are just trying to save time, and y'all assuming the buyer agrees to it, they sign the agreement, and then they'll go ahead and write up an offer for the buyer. Because in their mind, they're thinking, well, assuming the seller agrees to it, and I'm sure they will, Once the seller signs it, then I've already got the offer. Then I can go ahead and present the offer to the seller. Y'all, you can't do that. That's a no-no. Y'all, because what happens if the seller says no to dual agency? And now you've already solicited an offer from a client of yours that your seller said you cannot do. Now you got a problem. So y'all don't do that. All right. Now that I've kind of laid this groundwork here, y'all, here's what this bullet is saying. Y'all, before you can get the buyer to sign a dual agency agreement, they first have to sign a buyer agency agreement, y'all, which creates the single agency relationship. Y'all, they still have to sign a buyer's agreement. Y'all, you can't have a dual agency if you don't have two clients, right? You have to have two clients. And if that buyer doesn't sign an agency agreement, then they're not a client, they're a customer. So how can you create dual agency with a buyer that's a customer and a seller that's a client? Y'all, you can't do that. But what a lot of agents do, y'all, I guess they're just not thinking about it, or think just by signing the dual agency agreement that creates the agency relationship. No, it doesn't. You don't have an agency relationship with that buyer until they sign a buyer agency agreement, right? So that's what that third bullet is saying. The seller has to sign the list agreement, which if you already listed it, we presume that's already been done. But don't have the buyer sign the dual agency agreement before they sign the buyer agreement. Y'all, they have to agree for you to represent them first, and then we can talk about the dual agency. Okay, y'all, I hope that makes sense. Hopefully I didn't confuse you too much there. All right. Y'all, here it says customers may also be provided with an explanation of agency, and the brochure, I say must also be provided. So, y'all, again, even if they just say, I'm not going to be a client, I'm comfortable being a customer, that's fine. You still have to disclose everything. They still have to sign that agency brochure, just acknowledging that I told you. I gave you the option, and you chose to be a customer, okay? Y'all, that second bullet here saying, well, what if that first contact is by phone? I mean, how do you get some? I mean, if they call me, because we're not face to face, they call me, then you need to go ahead and explain agency just like over the phone. But then you can email a copy of the document, and I would assume probably most, if not all of you, are familiar with this anyway, but you will be when you get into real estate if you're not already. But you can do these signature, my mind just went blank. These automated signatures, so I can email them a form that they can read, and that basically they just click with their mouse to sign it, and then it'll come back to me, and now I've got it. That may seem a little bit aggravating to have to do that while I'm on the phone with somebody, but that's fine. The law doesn't really care if you're aggravated with it or not. You just have to do it. But you better get that brochure signed. I'm telling you. You carry on a meaningful conversation about real estate with somebody and they haven't signed that brochure, and something happens, you're done. It'll be over for you, I can assure you. And then, we know that implied agency is illegal, okay? So I'm not going to beat that up anymore. All right. And then you see where it's talking about agency disclosure requirements do not apply. In fact, I think it's like the last thing there right before you get to the brochure itself in your book. Pay attention to this. My guess is they'll ask you a question in some way, making sure you know this. So obviously there are 3 times when you do not have to disclose agency relationships. Number 1 is if the transaction is regarding the rental of a residential or commercial property. So basically, if you're dealing with a tenant, somebody wanting you to help them find a house to rent or a building, or whatever. If they're a tenant, you do not have to disclose agency. But number 2, when the communication from the licensee is a solicitation of business. If you're doing marketing or advertising, you don't have to put in your advertising or have to disclose what agency is in your advertising. That would be very difficult to do, first of all, I think, but you don't have to do that. Now, obviously, if someone responds to you as a result of the marketing you did, once they respond to you, now do you have to disclose it? Yes, you do. It's just saying here you don't have to put it in your solicitation or in your marketing, if you will. And then the third time is when it's regarding the sale of a property by auction. So if we're going to auction the property, agency disclosure is not required. Okay, so now if you don't have an auctioneer's license, that's probably not going to be an issue for you anyway, because you're not going to be auctioning the property. But there are a lot of auctioneers. In fact, I'd guess probably most auctioneers also have a real estate license. Because they're required, you have to have, even though you're licensed as an auctioneer, you cannot auction off real estate without a real estate license. So they have to have both an auctioneer's license and a real estate license. But at least in that situation, they don't have to go through or disclose what agency is, not if the house is being auctioned. Okay?